Uh, we're recording the conversation for later, so if anyone wants a copy, they're able to get it for their records. Okay. Um, so, Ms. Kirschland, would you like to come to the front and tell us a little bit about lending and what does that look like with estate planning? Because I know that there are many misconceptions and many steps that people miss as it relates to dealing with the lender before we get into Attorney Hall.
Yes. Well, what I would say is as a lender, my goal isn't to just help someone purchase a home. My goal is to help them create generational wealth. A lot of clients come and you hear him say, "Hey, me and my husband, we want to purchase a home together." Well, if you don't have those conversations with them together, you will find out that she may not have kids, but he have kids, and they're married and they are purchasing this home. This is an investment. This is the greatest financial investment. So a trust, will, or proper succession plan helps ensure that investment is protected and transferred accordingly to your wishes instead of leaving your loved ones with the uncertainty, having them going back and forth or having fighting in court where you could just take care of everything because it go beyond just paying your mortgage on time and keeping up the home. Is more to that. If you pass away and you have kids, or if you pass away before your spouse, or if your spouse passes away and he have outside kids or kids that is not by you, then that's another situation that you have to deal with. So this is very big for realtors, for home buyers, for home owners who can use this information to protect something that they had put their biggest financial investment into.
Yes. All right. And Attorney Hall,
Mm-hmm.
you're up. The floor is yours. So, would you like to tell us more about the differences, the benefits, the pros and cons, to having a will, a trust, when to use the LLC, and what is that entire succession process? How should that properly look and be structured?
So I'm trying to think of the best way to answer your question because generally when I would do this, I would start from front to back and simply say, look, everybody should have a will. Your will is going to tell you everything that you want done. And once you go see the Lord, then you come see me or somebody like that, and we do what you want done based off of what you wrote in your will. So you outline everything that you have in your will. Will can be what's called a statutory will, meaning it's prepared by me, the lawyer, or you can handwrite your will. You write it down in your complete handwriting and you sign it and you date it. That is actually a valid will. The key to the whole thing is it's got to be written by you in your handwriting only. You can't, I tell people if you're doing it like that, keep me one color ink. Don't give me black ink because you started writing it today and then you blue ink tomorrow. It could potentially hold up, but don't do it that way. And I'm gonna always tell you to come see the lawyer to do the statutory will because that will eliminate any, I guess, questions or issues that you're doing with it. But I'm gonna back up and go to the first thing that I heard that troubles me the most,
I
and
have a
that is
question.
I'm listening.
You can't type it?
Not in the sense of what you're saying.
Okay.
If it's going to be what's called an holographic will, it's got to be in your handwriting. You have to write it. It's got to be in your writing all the way across. Your sister can't write it for you. It's got to be your writing. And you have to sign it. You have to date it. It doesn't necessarily have to be notarized, but it definitely has to be your handwriting and dated and signed by you. Anything else on that? Nope.
No, that was it. I want to
All
know.
right,
Thank you.
cool. So I saw my man Malcolm on there, and he was talking about the trust situation. Here's the key on that. A trust is a tax shelter. That's all it's designed to be. It's a tax shelter. It is. I know what you hear and what you see on the internet and online. It does not prevent probate. It doesn't help you in probate. It really doesn't even pass your property on to your heirs. You are transferring ownership of your property to the trust, which is actually a mini corporation. That's what you're doing. Your heirs will never have ownership of that property. The trust will always own that property. So I'm unless you have very, very, very young children or you have a special needs child, I will never recommend a trust to a client. Create your will, outline what you want done in your will, and let's do it like that. That is the best way. That is the cleanest way to do it.
Got it. So you hear all this stuff about the trust protects you from lawsuits,
Mm-hmm.
right? Is that true or not true?
In theory, it's true, but it's a mischaracterization. Here's why. Because the only reason it's protecting you from a lawsuit, because you don't own it anymore. The trust owns it. It's not yours. And forget about the whole theory of a beneficiary. You don't get that benefit as you're thinking of like that. It doesn't
Oh,
pass to you like that. The trust owns it in perpetuity.
got it. Got it.
So
Thank you.
the way I would tell you to do it, if that's what you realistically want to do, you're gonna do two things. A, you're gonna write your will out. Well, first, you're gonna create an LLC. And in that LLC, you're gonna create that LLC, you and your children or whoever else you're gonna have on this. You're gonna transfer ownership of the property to the corporation, to the LLC. That's what you're gonna do. Because
Got
you're doing it as an LLC because you are the LLC. So realistically, it never leaves your ownership. Although in theory it does. Realistically, it never leaves your ownership because you are the LLC. In your will, you're gonna say, when I die, my ownership interest in the LLC goes to whoever you want to do it. If that's the way you want to do it. Or I'm not even advising you to do it as an LLC. I'm just giving you another option outside of doing
Right.
it as a trust. Because again, that's just not my thing. I am just not a fan of that.
All right. Thank you.
Yep,
Got a question.
I'm listening.
Once a trust is set up, could it be reversed?
So you have two types. You have what's called a revocable trust and an irrevocable trust. Generally speaking, they're going to always put you in what's called an irrevocable trust. And it's there. And what's going to have to happen, you're going to pay little or nothing on the front end. Well, then I'm lying to you. You're going to pay a number on the front end to create the trust. And then you're going to decide, I want to take it out. And you're going to pay even more money because you're going to now have court fees and you're going to have to go through litigation to get it out if you can find a way to break the trust. So it from a financial perspective, it does not benefit you. The cleanest way to do this is create your will, write down in your will what you want done, then we do what you want done.
Roger that.
And again, I keep saying the point, it's about a tax shelter. Trusts are designed for the rich and wealthy. Essentially, what happens with a trust is you got assets, and I'm gonna just use our mythical number. You got $1 million. You put your $1 million in trust. It's going to sit there forever. You're going to live off the residuals from that. You never touch your principal. You only live off your dividends and your residuals from that. That's why you put that in trust. A cat who owns two properties, it makes no sense for you to put two properties in trust, because who gonna take care of that? Who gonna pay the taxes on it? Because guess what? The lie that they tell you is there's no taxes involved in it. It is. You know how you know there's taxes involved in it? You got to get a tax ID number to create your trust. Who gonna pay the taxes? The trust? Where does the money come from? If we just got these two houses in there, where the money come from? Makes no sense to put anything in trust unless you have a lot. Create your will, pass it down to your children. And that's the other thing. You may be a property owner. You've got several pieces of property. That's your dream. That may not be your kid's dream. Your kid may be an artsy kid and they like to do something else.
Amen.
Your kids are your legacy. That's what I say. Your kids are your legacy. Everything else is just an asset. Let your legacy use that asset to chase their dream. You chased yours already. You dead and gone. It ain't there for you no more. It's theirs.
So, Mike, this is Angel. I've heard that at least the minimum for a trust should be about 15 million. Would you agree with that number?
I would tell you, talk to your financial advisor. If you don't have one, get one. Because they can tell you, and I'm only saying it like that because they're going to tell you, I'm going to create your trust. I'll set up the paperwork. You got to tell me how you're going to fund it. The second you tell me how you're going to fund it, I'm going to tell you who to go to. They will tell you how your money is going to grow, what your percentages are on all of that. And it's going, from there, you got to figure out what makes sense. Because maybe it don't make sense. Maybe there's some other investments that they telling you should do.
Okay. So this is why part of the team is going to be having an attorney to help decipher, as well as a CPA or someone in the financial industry to really assess where someone's assets are and what are they, and are they able to be passed on. Okay. All right. So does everyone know what a will is? Okay, let's just go over a will. We want to make sure everyone knows a will. And the other that I hear people mention is also a power of attorney. And I want people to understand that a power of attorney only happens when someone is living.
It no longer exists once the person dies. And so and I'll jump in again, Angela, I'm sorry. But when you are seeing your lawyer and you're creating your will, you should really get a full estate packet, which includes your will. You can do a power of attorney, but you also want what most people like to call the living will. It is really more of a do not resuscitate form in there. And you can say whether you want to live on the breathing machine or not. Those three things should be in every estate packet that anybody creates for you.
All right. And you want to briefly talk about power of attorney so that way anyone who has a holding a power of attorney understands the length and what it can and cannot do.
So the key to it, though, is realistically, you got two types, well, more than two types, but generally you're going to have the general and then you'll have a medical. The general power of attorney allows you to generally do everything for the person. Medical will be specific to making medical decisions for that person. The question that you get a lot is, can you have more than one person on the power of attorney? The answer is, yeah, I guess you can. To me, it defeats the purpose, but you can.
And are there any steps, because I want to make sure that you answer everything before I start asking too many questions about, particular things that everyone has a good understanding of what an estate planning, process should look like.
So when you say what is an estate planning process should
So
tell me what
let's
you mean.
walk us through a consultation with Attorney Hall if they were to come in.
Gotcha. So first thing we would talk about, realistically, we would get an idea of what's your assets. Give me a listing of everything you have. Then we're going to talk about what's your thoughts or what's your ideas on, when you close your eyes, how do you want everything to be distributed? And, we'll put certain little disclaimers on it, like you can't do what they call, you can't rule from the grave, and that you can't say that I want my house to go to my oldest son, Bobby, and then when Bobby dies, I want it to go to my grandson, Joe. And then when my grandson, Joe, die, I want to go to the next kid. It doesn't work like that. You got one shot. You give it to Bobby. Once Bobby got it, it's Bobby's. Bobby then controls who does what, because Bobby owns it then. From there, we can then write out your will, say everything in there. Now, the one thing I will say is we get into debts, things like that, but truthfully, I'm not going to include any of that in your will. I'm not going to include anything as it relates to life insurances or anything that is beneficiary based, because it belongs to whoever the beneficiary is at that time. You can write in your will, I want my life insurance proceeds to go to X person, but if you already have Y person designated as the beneficiary, it's going to Y person, not X, because Y person is the beneficiary. Another thing to look at, we'll get into the fact of, on your bank accounts, do you have a death benefit on your bank account? If you do, again, the death benefit is beneficiary based, in that it says upon death, everything in my bank account goes to this person. That's who it's going to. Even though you may write in your will, I want it to go to my niece and nephew. If you have your son listed on there, your son gets it. So we go through everything that you have and what your thought process is on it. It may make it easier. I typically suggest to people, specific to bank accounts, if your financial institution allows for a death benefit, you should do it, simply because that gives you access to some cash flow once the person passes. Because what you find is, sometimes we think somebody has insurance and then we learn that they don't. And then everybody's scrambling to try to pay for the funeral. Well, they got $15,000 in the bank account. You can at least get to the bank account and pay for the funeral out of the bank account. So one of the things I always do is encourage clients to check with your financial institution, find out if they have the death benefit, and sign up for it.
Mr. Hall, we have a question in the comments.
I'm listening.
Is probate still necessary if a will is in place?
Yes, kind of goes back to what I was saying at first. Your will, you writing down, you telling me what you want to be done. Your will tells me exactly what you want done, how you want it done. Probate affords me the ability to do it for you. So you write down, I want my house to go to my son. When you pass, it does not automatically pass to him simply because you wrote it down right there. You just told us what you want to happen. Probate makes that happen. Probate passes it to your son formally. You'll get the judgment of possession done. People are always asking, how do I get a new deed? Well, that judgment of possession is the new deed. That just transferred ownership of the property to you.
Okay, I have a question for you. I
Mm-hmm.
have a minor child.
All right.
I have a home and I have
Mm.
businesses.
All
My
right.
mother is of age. So if something would happen to my mother, because she's a beneficiary on everything, would I be able to put my minor child as the beneficiary, or would I have to appoint someone else?
Now you can make your minor child can be the beneficiary. You can make whoever you want to be the beneficiary. When you say minor child, how old is your child?
6.
All right. I'm about to be a hypocrite because I'm gonna tell you something that we just did. And what I mean by that is this. The only time I put in something as it relates to a trust, you can set up what's called a testamentary trust. Now, what that is this: in your will, I'm going to state in your will that only because you have a very young child, we're going to set up the parameters of a trust for you within your will. We're going to write it out that says you pass, we're setting up the whatever your child's name is, trust. That's what's going to be the name of the trust. We're going to outline everything that should happen within the trust. We will be specific enough to outline, hey, look, at this point, at once a child reaches this age, we're going to give X distribution from the trust. Once the child reaches 21, we'll give another distribution in a specific amount. And you can do it. That would be the only time I would suggest that if a person has health issues, that's the only time I really advocate that you do this, simply because you're protecting your kid at that point. Or like I said, if you have a special needs child, I'm gonna always tell you to set that same thing up in your that same type of trust in your will, but it'll just be called a special needs trust and it'll have some other type of language in there.
Okay, okay, thank you.
But what I will say to you on something like that, as I'm thinking about it, consider how you're going to fund the trust. And what I mean by that, and I'm not so much directing it to your part about your mom, but strictly to you, because for you, it would be, I would tell you, make the trust the beneficiary on your life insurance policy. That way, the second you pass and the life insurance is involved, the money never goes to anybody else but the trust. It is payable to the trust. Now, for you, you're going to have to think about who you want to be the trust administrator, because if something happened to you tomorrow, that person's going to have to administer a trust for at least however long you want it. Because normally I would set it up till age 25, age 31, 32 at the latest, because I guess my opinion is just simply, if you ain't got it together by 30, you just ain't gonna never get it you're just not gonna get it together. And I can't hold your hand forever. But at least we'll have you set up and you'll put it in like that. But that's one thing I would suggest, if that's something you were thinking about doing it in that fashion, because that's how you'd fund the trust. Don't put the house in the trust. Fund the trust through the life insurance.
Okay, so even though once I pass, my home is paid for,
Hmm.
leave everything the way it is.
Yeah, leave the house to your child.
Okay, okay.
Because see what'll happen, let's just assume for a second she is still a minor.
Mm-hmm.
Once she does that, she's a minor. You can, she's not going to be able to get it. So there's going to have to be what's put in place called a minor's mortgage or a tutorship, which will outline how and who would administer the child's affairs anyway. You can kind of dictate that out. Now, the other side of that would be you got to figure the father may be involved too, and how the father is going to be involved. Again, The father does not have to be the person to administer the trust or be the executor. You're setting it up, so you're gonna
So
be able
I
to
can put
dictate.
whoever I
You put
want.
whoever you want because it's
Okay.
you doing it for
Okay.
the benefit of the kid.
Yeah, because and see I'm glad you say that because I'm protecting her and we're
Mm-hmm.
not together. So, I don't want anyone to come in on what she's inheriting and take
Mm-hmm.
it from her.
Yeah.
So,
No,
okay.
you're good. You're
Okay.
good. Do it in that way. And so here's it kind of to that last little point. I tell people you can't do this, but they always want to do it, but it ain't worth the paper it's written on. You cannot write in your will. You should not write in your will. I'm gonna say it like that. That when I die,
Took it off speaker. No, I didn't.
you can't hear me.
Yeah, I
I
can hear
can't hear
you.
you.
Yeah, we
All
can hear
right.
you now.
All right. You cannot write in your will, when I die, I want my mama to have custody of my kid. That it ain't worth the paper it's written on. It just don't work like that. I can use it in court, but it's not worth the paper it's written on. So don't do that. Next question.
So I'm going to ask a question here. So if someone in Louisiana, let's just say they were buying a property, right? They don't update their will. They don't have, power, nothing in order.
Mm-hmm.
What does that look like on an average court date? Because you're running for judge.
Right. Family court. That's right.
Family court.
November 3rd. Vote for Michael Hall now.
So with you running for judge, they come
Mm-hmm.
in, they have to see you. What are you anticipating that would look like, for the average African American who has nothing in order? How does that spell out? Because we're telling people what to do, but there obviously are many people who don't do it, and we want to avoid that. So tell us what you have
So
seen representing those or on the other side.
no, I got you. So here's the thing. A friend of mine always says that if you don't set it up yourself, the state dictates to you how everything's gonna go at that point. So, and essentially, here's what happens. Let's assume for a second you don't have a will. You got 3 kids. By statute, by law, no will. Everything goes to each kid equally, right? But let's assume for a second you don't want that. It's always been your intention that I want my house to go to this particular kid because this is the one that's here. This is the one that's doing it. This is the one that's here helping me out doing everything. You don't write it down. You don't create the will. It goes to everybody equally. And here's what happens when you're doing that. Generally speaking, what always comes about is now mama or daddy passes. All 3 of us owns this property together. The problem is we don't really like each other. So the 3 of us can't own this house together because we don't like each other. So what happens then? Well, that legacy, well, them 3 legacies that you created, they're now at war. And what should have been an asset for the family is now going to A, be sold because we can't live together, we can't own it together, or B, somebody's gonna have to buy the other 2 out. And if there's still a mortgage on it, who's gonna be responsible for the mortgage? If nobody's responsible for the mortgage, then y'all know it goes up for sale.
Okay. Now, on that note, Kirschland, let's just say someone does pass, they're coming now, calling the mortgage lender. You answer the phone, and guess what? They don't have a will, they don't have anything in order. What does that look like from the lender's side?
To refinance it, we would need paperwork. We wouldn't, or it would have to go in all three of the kids' name. All three of the kids will basically be basically like buying the house all over again in a refinance.
Okay, so if someone calls, they don't have documents in order, what's the first thing you're going to ask them? Let's just say they don't have any paperwork. There was no will. There's no one in charge. How can a family member actually communicate with the lender to find out about the mortgage payoff and, try?
We can't do anything.
Can't do anything.
We cannot do anything. We cannot give them no information because it's for the mother, it's for the father. So it's private. Even if they come with a death certificate.
So what's going to happen in that situation is they're going to have to come back and see me. We're going to have to open the succession. They're going to have to appoint somebody as the administrator. At that point, that person will have court authority to, I guess, act and speak with you. But I guess my question to you would be this. Even in running it like that, no judgment of possession is done. Can you still, I guess, run everybody's credit and see who qualifies? And if only one of the three qualify?
What you mean? Once I received documentation?
Once you have an order saying, Brother Johnny is the administrator of this succession, can you move forward at that point?
Yes, if the judgment would say that John Doe is the primary person to handle everything on there, then I will run John Doe credit. If his is a 400, we in trouble. They got to come back and see you and appoint someone else.
Even if all three of them are going to try to buy together.
And that's so that's one thing that a lot of people does not realize. When it's more than one person purchasing a home, when we run credit, we use the middle score of the Lloyd's number. So if Jane Doe
link is the person,
yes,
can make or break.
So if Jane Doe middle score is a 700, Billy Joe middle score is a 650, and John Doe is a 400, gonna pull that 400. Yes. I'd have had husband and wife say, well, can I just take him off? No, ma'am.
So there is no way to protect, like if I have a mortgage on my home and something happens to myself or my husband, and we already have it set up that the kids get it, and let's say the kids are bickering, like that scenario that the attorney just gave. Let's say the kids are bickering and one of them wants to buy the others out, or they all want to equally do something. So they still have to be able to be approved to get the loan, but I have a loan in place. Can they just continue making the payments?
Okay. The thing is with that is if everything is still in your name and your husband's name, that could cause conflict with the insurance company. If something happens to the home and they file insurance claim, that check is going to come in your name and your husband's name.
Correct.
So it will just be best once they do the succession and get all the paperwork done. And if they're going to keep the home, to do everything in their name so they can take care of all the obligations with the home.
So will they be doing an assumption at that point, or like what type of loan? Or
it will be a no cash out refinance.
Oh, so it would be, so if I have a 3% interest rate and the market rate is 10%, then they have to refinance it. So they couldn't just assume that mortgage, because I would have to be alive in order to sign off to allow them to assume it.
Unless you will have it in your in a will or something like that with stating, so they will go through that mortgage company, and then they will go through the just say you have a loan with Planned Mortgage, Planned and Lending. Well, they will contact Planned and Lending, and because they're the they're the company that's holding your mortgage, and if they provide the documents that Planned and Lending is asking for, and they can't provide it, and they can afford that mortgage, then they can assume it.
Okay.
Yes.
Okay.
So,
Okay.
so if
But because I'm with Relying Mortgage, we're more of a broker. So if they come to
Okay.
me, you see what I'm saying? They come to
Mhm.
me, I would do a cash out refinance solely in their name. But if your mortgage is with Standard Mortgage and they say, "Hey, I make the income to keep this $400,000 house. I have the credit," then I would direct them to go with Standard Mortgage and see what Standard Mortgage has to offer. If Standard Mortgage have nothing to offer them, then I would tell them, "Well, come on, let's do a no cash out refinance."
Okay. 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 That's something else to know.
Hmm.
Thank you.
Okay, I have a question. Let's just say married couple, one spouse passes, uh, the other spouse is not on title, right? There are kids. How do we handle if the kids are grown versus the spouse uh, with the
it,
mortgage?
was there a will created?
No, no will. We're gonna just we you know
That
saying this
spouse is
is
out of luck. That spouse has a problem. That spouse has no, as I appreciate it, that spouse
Has
name's
no
not on
ownership.
anything. She's got no ownership in the property. The children are grown and they own the property. It was his separate property, so that spouse does not have what's called a usufruct. She don't have a right to stay there. The children can say, "Get out" at any time, and she got to go. That spouse got a problem.
okay. Right. And those are the nuances that people really don't understand, and this is why you have to have things in order.
Wait, I think I,
I
I,
have a
I think
question.
I missed that one. I think I got distracted while you were talking. But so you're saying that if there's a spouse, you're married and one spouse dies and there are kids involved, then that spouse don't get the usufructs of the house?
Well, under the example that she gave, it
Okay.
was the husband's separate property.
Right.
It wasn't
They weren't
community.
the
It
spouse
was
wasn't on title.
Okay.
so in community, the spouse has an automatic usufruct on
Yes.
community property, automatic. However, if it's the spouse's separate property, there unless you write in your will that my wife, I give my wife a usufruct, she doesn't have it unless it is specifically awarded to her by way of the will.
Okay, perfect. Okay. I got you.
And I want to say this. We have a program that we offer. It's called Sold and Separate. That means if someone wants to purchase a home but still legally married and you all are not together, then you can still purchase a home sold and separate, but that other spouse has to sign their rights over. So we do have a program for that.
I had
And
sat in the CE class a few months ago, and they were telling us that if you're married and your spouse's name is not on the property, they still are entitled to benefits from the property if they help pay the mortgage or any bills or anything like that.
Your spouse is entitled to certain reimbursement claims if
Okay.
something came up, but they're not entitled to ownership. So you're, as the spouse, y'all been married for 10 years and we've been paying this mortgage for 10 years. I get a reimbursement for the principal amount of the mortgage paid, not the interest, but just the principal. I'd be due one half on that.
Okay.
anyone else, any questions? Okay, I have one. So, and this could go to anyone, either of you. Beside having things in order, we often talk about, in Louisiana in real estate that it isn't, majority rules. So, their family members may be inheriting property, and I guess this would be more to you, Attorney Mike. What are some of the common delays that you have seen in your years of practice with families as it relates to a state trying to sell and liquidate a property? Because we know that there are quite a few.
Well, the big delay is, so look, you're going to start with the delay of, I can't do the succession until you get the death certificate. On average, it's going to take you 4 to 12 weeks to get the death certificate from the funeral home. But then you get the situation of, once you got it, nobody really wants to do anything. So until, I'm not gonna move until y'all come see me and say y'all ready to move. But we having these family meetings and nobody really wants to participate until you have to, and then we start doing it. So generally the delay is with the family members. That's where the delay comes. It's when do you want to do it? Because like you were saying just now, I can coast along until something comes up, until I got to renew that insurance or something like that. And they tell me I can't, y'all can't renew it because it's still in your mom and dad's name. People go people go years with their deceased parents still owning the property until they have to do it. So that's where the delay really comes in.
So really the delay in taking care of all of the legalities.
Mm-hmm.
One of the others I think, we see is family members not agreeing.
That's what I'm saying. It's with the family members.
Some want to override others, which, it's not a majority rules. It's, all that are entitled have to be. You and I spoke about something briefly earlier, just having one person versus having everyone. Would you like to go back to that potential situation?
Well, yeah, it kind of goes back to what we were talking about earlier. I guess my question was asking, I've had it happen a few times where I've got married people who, when we're going through a divorce, one spouse, we only have one spouse on the who's the owner of the property, one spouse on the mortgage, on the title, on everything. And I'm asking, why was it only one person? It wasn't an issue of credit or anything like that. It was, my real estate agent told me to only put one person on the mortgage so we can free up the other person's credit to buy another property, a few months or what have you later. And the point that I was making in that is, that's a terrible way to operate in divorce court, because again, you have no rights. Kind of like you were saying, all I have is a reimbursement claim on mortgages. I got no ownership interest in the property. I think the better play to that would be, when you're doing that, if that's something you're gonna do, make sure we tell them, look, we're not going to put you on the property, but we're going to immediately sign an act of donation where I'm transferring, or I am giving you your 1/2 ownership in the property, which would be done under community property laws.
I have a question.
Mm-hmm.
Say for instance, I'm my mom's only child, and I have siblings on my dad's side. I'm unmarried, and I pass away. Who's entitled to the house? Is it my mom and the siblings?
Give me that scenario again.
If I'm an unmarried female, my mom has only one child. My dad has 8, and I pass away. Does my mom get rights to the property, or everybody? My mom and my siblings.
So technically, your parents have what's called the usufruct over the property, but your siblings actually have what's called the naked ownership of your property.
So what? How does that look? How do-
Ownership. Your siblings own it, your parents have the right to use it.
Oh wow. So my
So
parents own it?
no. So you have a kid, right? Or did you say you have a kid?
No,
No,
no kids.
no children,
No
no
kid.
children.
That's what I thought you said. I just wanted to be sure. All right. So yes. So short version is you need to write a will that says when I die, I want my house to go to my mama.
Wow.
But suppose something happens to the mother and it still goes to the siblings because the
Uh-uh.
mother.
Here's what you do.
I thought the
That-
mother had
it-
more rights than the siblings. That's
there is no maternal preference in any form or fashion in the law. So here's what you write. You write, when I pass, I want the property to go to my mother. If my mother predeceases me, then you say who you want it to go to. So if it's your mother first, you say my mother. If my mother predeceases me, then my father.
wow. So they can't stop the mom from living in the place, but oh Lord, that is insane.
You don't need to panic. You know what to do now. All you gotta do is go do it. You
Go
good.
right.
I
No,
have a question.
I have a client that this is going on with right now, and that's the issue. The mom is alive.
Mhm.
He has siblings on the mom's side and the dad's side.
Is your
Um,
client deceased?
yes.
Okay.
So I told them that they may have to do I said you're gonna have to do an open succession, but the property is like $18,000 in debt because the mortgage haven't been paid since I told because of the
Tell that mama don't open that succession. Don't open that succession if you don't want that debt. Because what happens is
oh
when you do a succession, and while you are taking on the asset, you're taking on all the debts and liabilities that go with it as well.
oh Lord.
So they're
So
just
it
stuck. So in other words, they have a house. Yes, it is in debt. They cannot sell it
they're not
because they
necessarily
can't open
stuck.
succession.
If so, look, let's assume for a second two of them get together and say, look, we're gonna cover the 18, we're gonna do everything. No, that they it's gonna be theirs at the end of the day. They're not gonna be putting up the 18 just to cover everybody's debt and then say I want something from it. They're gonna cover the 18 and then they're gonna want it back.
Yeah.
Right.
But it's still a business at the end of the day.
Yeah,
But
'cause-
let's just say that the property, Javon, is the property worth more than the debt? I mean, it should be,
well,
even with the payoff, or you're not
yeah,
sure.
it is the payoff. Yeah, it's worth more, but it has a lot of it has a lot of issues that needs to be corrected. But if you sell it as is, they'll get a good profit because it's a double.
So sell it
Um,
as it is. That's what
yeah,
I was
so
getting ready to say. Just tell them
yeah,
sell it and walk
yeah, so
away.
but they still will have to do the succession, right, to sell it, right?
But I think the play should be, from your perspective, is get the deal set up first.
Yeah,
Have the deal set up to where essentially they're just doing the succession to get the deal done and they're not losing anything.
yeah,
Because it's a debt, the debt's going to immediately and automatically be paid off. So they're not losing.
right.
Yeah, but they shouldn't wait much longer because
No, not
in a
no.
moment, it sounds like they'll be in foreclosure.
Well, they did the I forgot what it's called, but they he had when he got so far into the to not being able to pay the mortgage, he did the I can't think of what it's called. Oh God.
Where they
Would they give him time to pay it?
The modification,
No.
a forbearance.
Forbearance. He did a forbearance. And so they extended the forbearance. And so in October, I believe they have to come up with the $18,000.
But is the forbearance still in place even though he's passed away? Does that
Yeah.
automatically pass to the heirs?
Well, the forbearance is still in place. It doesn't expire till October. They're supposed to be getting a death certificate to the mortgage company, because the mortgage company wants that for whatever reason. And I told them that they
Approved.
should seek legal counsel, because I'm like, once you give them that death certificate, who knows how this going to turn. So I suggest they seek legal counsel.
Kirschland, would you like to answer that? What would that look like if it were your company?
I was just sitting here thinking, if it's in forbearance and the forbearance is over in October, I would say for them to go ahead and get everything that they need to get in place to put it up for sale. So once the forbearance, so by the time it's October, they don't have to worry about
What happened,
that.
Jerrell?
They don't have to worry about that
Yeah, what happened,
remaining
Jerrell?
balance of 18,000
You can hear me?
coming up due.
What happened?
So they just need to get everything done before that forbearance comes to an end.
Okay. All right.
We have a question in the chat. Is there any way to avoid opening a succession and going through probate?
Not if you want to properly transfer the property.
Can you hear me? This is Diana.
Yes, we can hear you.
So I asked that question, and so I'm like so confused now, because I've been hearing all of this stuff about to set up a trust, and so that you don't have to so that your heirs can avoid probate. But what I'm learning now is that that's not necessarily true, because you have to have, well, based off of this conversation, what I'm learning is that the trust is basically a tax shelter for the rich, not for everyday people that may have just a few properties that they want to leave to their heirs. That would not be in the best interest to put that inside of a trust. I'm confused, because I thought that by doing that, you would be able to, your heirs would avoid certain taxes, maybe not all taxes, but avoid certain taxes, and avoid having to open succession and go into probate. So that's incorrect information. Is that correct? Am I understanding that correct?
It's not that it's incorrect. It's just it's
Not
not that
true.
it's not correct. It's just not accurate. I'm gonna give you. Here's what you got to think of.
Okay.
Are you married?
Yes.
All right. You and your husband own a house. You and your husband own a house. The house is worth $500,000. Well, let me back that up. No, we'll call it. The house is worth $500,000. You still owe $250,000 on it, right?
Okay.
So realistically, your house is valued at $250,000. So that's the equity in your property. But let's just work from the five. Let's just say your house is worth $500,000. You own one half, your husband owns one half. I'm gonna kill your husband first, not you, since I'm talking to you. Your husband passes away. Your husband's ownership interest passes to the children.
Okay.
So all they really get on that part is $250,000, right? The death tax that everybody's talking about is $1 million. That's the threshold. You're at 250. Let's
Mhm.
cultivate a couple of the other assets that you may have there. And again, remember, you're cutting everything in half. You don't get to the $1 million tax threshold, so you don't pay any sort of death tax that they tell you this is what it's protecting you from. You just don't. Also, remember, you got to start talking. You look at that. You start looking also at liabilities that exist. That mortgage is a liability, so that's how you start reducing these things. So you're gonna be reducing the number. The short version is kind of what you were saying. For the average regular person, you never get to the $1 million tax threshold. It just makes no sense to do it. Secondly, it makes no sense to do it because you're transferring ownership to the trust. You don't own the property anymore. Or in your case, your husband's 1/2 interest is put in trust or the house is in trust. Y'all can't do nothing with it. You can't use it. Your house is an asset that could be used. You don't want to use cash. Maybe you can do a line of credit, home equity line of credit or something like that. You really lose that option once you put it in trust because you don't own it no more.
Okay. Okay.
And
So go ahead.
No, I'm sorry. I just wanted to say, Miss Deanna. I also is Ms. Lauren Thompson. She's on this call and she's a licensed CPA for Louisiana. So she may also be able to help you with that financial tax bracket and all of that other information as well. Lauren, is there anything you could help her with?
Yes, basically pretty much the attorney Mike Hall said everything when it comes to the revocable trust. They say revocable because you can revoke it, but pretty much he said it all. You have to get to that $1 million tax threshold, and most likely if you don't have that, you don't have to worry about it.
So if you're not at that $1 million threshold, it doesn't make any sense to have a trust.
Basically.
No, I wouldn't advise it.
Okay.
And let me ask this, and this is why we're actually doing a call because, there's so much that people put out on social media, put it in a trust. And, I think people say things, we hear because we're looking for answers, but they don't really go into the legal depth and detail, that it really is the benefit. The other in Louisiana, our property prices, typically are not as high as some other states. So when, they mention $1 million threshold, I'm licensed in Florida and working on Nevada. So I see many properties in trust, but those are the $1 million properties that are multi-million dollar properties that are in a trust, just one single home. Whereas here, our homes are not as pricey. So, I think, keeping it in mind, what's going to be the best overall structure. I've heard many other attorneys say, you put it in the LLC, you can protect yourself, hold on to it, obviously the will and insurance. So I would, anything less than $1 million, I would just focus on insurance policies. Because your overall is how do you leave them in place? You leave a property, but you still have to leave them in place to take over and care for it, correct? I mean, that's the overall what we want. And I only say that because I have represented many families where they inherited property and they were asset rich and cash strapped. Mm-hmm. And all they had was assets and they had to sell it off because they're like, okay, what do we do with it? We can't afford the taxes, the maintenance, the upkeep. They weren't financially prepared for it. So to avoid that, I just say, I think insurance, is probably the safest.
Okay. I have a question. Hello?
Mm-hmm.
Yes, I want to know, this is a family home that I'm in. And I do have a will and a trust, but in there's I only have one child. And if something happened to him, I put his 2 sons down. But my brother's also is on this house. So would his son get the other part of the house, or does it go to his wife and his son, or just his son?
Wait, say that. Say that again.
The house I'm in is a family home,
So how
and
many people own the house?
me and my brother.
All right.
And I did a will in the trust already. And I have my son. If something happened to me, it goes to him. And they say it trickled down from him to his sons. So I was wondering if something happened to him or to me, his son would get the other portion of the half of the house, since it's a family
So
home.
so right now it's co-owned property. You own one half, your brother
Right.
owns one half.
Yes.
When you pass away, your one half interest goes to whoever you have listed in your will. Your brother, if he doesn't have a will, his one half interest goes to his children.
Okay. So his wife wouldn't have a part of this house, right? And just go
I
down to
don't
his
well,
child.
I don't know what's if he has a will, maybe he has in his will that it goes to his wife.
Well, because we had signed a paper in the attorney that we went through. She said since it's a family home, that the wife would not have a part of it, go down to the children and their children.
Well, he can write and leave whoever, he can leave it to whoever he wants. So if he says in his will it goes to his wife, then it goes to his wife.
When I signed the paper with the attorney, she said by it being a family home, it would go to his son, and then from his son to his children.
Does he have a will?
I think he do.
So whoever he has listed in the will, that's who it's going to pass to.
Even though we did the open session and all that on the house.
It doesn't matter because y'all two own it now. Y'all two are the co-owners. So he can leave his one half to whoever he chooses to.
Well, I didn't know that. In my understanding, that by us open the session with the attorney, she said by us being a family home, that it was going to trickle down and it was going to stay in the family.
First off, I want you to stop saying it's a family home. It's co-owned property is how you got to start thinking about it. You own one half, he owns one half. It's co-owned property. So whoever the other owner decides he wants to pass it to, that's who gets it.
Okay.
All right.
And so what happened if like if my son passed, or just say if I pass, and so I have in the will that it goes down to his children, how will his children be involved in that? But they underage right now.
You have in your will that when you pass, your property goes to your son, right? Is that what you're saying?
Yes. And then
All
I
right.
also have, if something happened to him, it goes to his
So
son.
if your son predeceases you, then it passes to his kids. Right? That's what you're saying?
Yeah, that's what I'm asking.
All right. So that's fine. It can be done that way. But again, because they're minors, there will be what's called a tutorship and or a minor's mortgage that will have to be put in place within the succession proceeding that's done on you.
House is paid for.
But yeah, it's called a minor's mortgage. You just set it up that says somebody's going to administer everything for the children because they're minors.
Oh, okay. I got you. All right, I'm glad to know that, because I thought that if something happened to my brother, that it'll go to his son and not to his wife. So you're saying if
And
he
look,
have a will, that it could go to her.
and I'm leaving out a key part. I'm really intentionally doing it like that because I don't want to get too deep into it, but I guess I gotta say it to you now. But so Louisiana has what's called forced heirship. Anybody under the age of 24 of the first descent, they're deemed a forced heir. So technically, under the theory that you're saying, let's assume for a second your brother has two children and they both when at the time he passed one's 17 and one's 15. His two children are deemed forced heirs. So they have to be left 1/4 portion from his estate. So technically, under the theory that you're saying, I'm going to assume that's what the lawyer was trying to explain to you, the theory of forced heirship.
Well, his son is like in his 30 something. So she had
Oh,
told
so
me that
so
since
it
I
don't even
read,
matter at that point then. It go if he
yeah.
puts his wife, it goes to his wife.
Oh, okay. Well, I know because she was explaining to us that by me had remodeled the house and put money in the house to do the house, that we both could do half of everything since he part on other house, but I put majority of money in the house. And she was
Well,
saying that the only way that
that's a
his
different
son or
fight you
whoever,
got. No, that's a
right.
different little. That's a different fight you got as it relates to what you put into the house. That's a different fight.
Okay. Yeah, I just wanted to know because I didn't know how it goes, but because I kept asking her, and she was saying since the home has already been established through my mom and dad, that she was saying that it goes to our children and
Mhm.
not to the spouse. That's what the attorney said. So I just need some clarification, and I will go
So
back and.
I'm gonna give you the easy version of that then. If there is no will, it automatically passes to the children. If there
Okay.
is a will and it says it goes to the wife,
Mhm.
then it goes to the wife.
Oh, okay.
All right.
I'm glad to know that then, because I sure was on the wrong impression that it was going to his son and from his son to his children, since it was a family home. So that's what I want to know.
Okay.
Thank you.
We're going to start wrapping up, but Mike, what would you say is the age that someone should consider writing a will?
When you start acquiring assets.
Okay. So the minute you start acquiring assets, there's no age, never too
Oh,
young.
well, no, think about these child stars who've got
Inheritance,
millions. They got to go somewhere, so they should write it down. So I say, when you start acquiring assets, and that's when you should start looking at it.
and we have quite a few realtors on the phone on the call. So what is the one thing that a realtor should be asking a client if they're about to take a listing? What is basically the first thing that
So no, I will be perfectly honest. Now I'm going away from since you asked that question, going to the other side of my family law hat. You should realistically be getting into where they are, and here's what I mean by that. Let's assume for a second that you've got a man or woman, it don't matter, but they've acquired, you got an investor who's acquired things, property, and he or she thinking about getting married. You need to tell them, get a prenuptial agreement. You need to tell them, start designating this stuff as my separate property and registering it as my separate property, because you mad day comes and then you see him, and not because of death, but well, yeah, maybe the death of your marriage, and you don't have your business and your paperwork squared away on that side. And the one thing I tell people all the time, marriage is a business and it should be treated as such. Make sure your paperwork is together. So that's the one thing I would say, start encouraging man, woman. If you acquire things, that's your stuff. Protect it.
All right, that's another conversation.
That's another conversation, but that's the one
That
thing
is
I
the
think
best.
y'all should be saying.
Okay, so that means we're out selling, ladies. For those realtors that are on the call, ladies, gentlemen, whoever, when we are discussing with a client, showing property, we should be guiding them into proper preparation. Eliminate a hassle. All right. And if you need an attorney, unless he wins and takes the seat,
He's gonna win.
you call. He'll no longer be available. I promise you. His days and nights will become tied up in court law.
Angel, I want to tell everyone to check the chat. Everyone leave your contact information if you're a realtor, lender, CPA, business owner, wherever you are, leave your contact information in the chat so everyone can network with one another. Also, the replays will be on our YouTube channel. The link is in the chat. Please click it. Please click it and subscribe. Also, there are PDFs for about tonight's webinar. Please download them directly to your phone, computer, wherever. Look over the information and look out for our next webinar. Thank y'all so much for joining. Thank you so much, Mr. Michael. And I'm going to reach out to you before you become judge.
I'm here. Call me.
And I do want to say, thank you to both of you. You know, these conversations mean a lot. I know in the community, we definitely have to do our part to educate not just ourselves, but our clients and our community. So does everyone see the PDFs? And our call next month is Luxury Real Estate Decoded. So, we hear luxury. We'll have our lenders, talking about jumbo loans. We will definitely hear from our contractors who specialize in luxury. So we know what makes a luxury home, the difference between a luxury and a regular home, a designer who's going to talk about design aesthetic, and our realtors that specialize in luxury. So we have, always just a number of questions that people ask, what are loans available? If anyone missed our previous, which was Soul Separated, reach out to Kirschland or myself, and we'll make sure you get either the notes or the video of that, where we talked about prenups, postnups, what happens, before, after, and during marriage. Or yes. Any other questions before we let Attorney Hall enjoy the rest of his evening?
So how do we get in touch with Attorney Hall if we're interested in doing a will or a trust?
You can call me 504-621-2606.
My apologies. I had to get my pen ready.
Let's put it in the chat.
Hit it in the chat. Yeah, all right.
Thank you.
And if anyone is interested in a meet and greet or a fundraiser for Attorney Hall, he's running for judge.
Yep.
Quick question. What happens to the office if you take the bid, sir?
What you mean what happened to it?
Yeah, we want to know the plan. You're still available? You're not available?
No. Once I win, I am no longer able to practice. I am a full-time judge.
There you go.
Yeah, it will not be open anymore. If that's the question. No.
Oh, okay.
Yeah.
Okay.
So you got 3 months to get it.
I got 3 months, so I'm calling you tomorrow. Okay.
To get whatever you need to get out of me.
Did everyone see that? Wait, do you see the number, Latanya?
I just see his email address. Is that correct?
Wait, call out the number again, Mike. Let's see.
504-621-2606.
621-6206.
No,
yes.
621-2606.
Oh, 26.
2606.
Okay, perfect. Okay, so I'll reach out to you and hopefully we can schedule an appointment to meet.
Excellent.
Perfect. All right. Thank you for putting this on.
You're very welcome. Anyone have any other topics they'd like us to discuss? co-host with us, you're more than welcome to reach out. I think-
I'm sorry, Angela. I didn't want you to get off before you tell them that we have a podcast that is coming.
Yes.
Closed Conversations with Angela and Kirschland. And that's why I told everyone to put their information in the chat, because we will be reaching out to you all to be coming on the podcast. We're going to continue to do the webinars, but we're actually taking it in front of the camera live.
Yeah.
That sounds amazing.
We hope so.
Congratulations.
Yes, congratulations.
Well, thank you. All right. Any other questions directed to Kirschland, any of the realtors or Attorney Hall? No? All right, everyone. Enjoy the rest of your evening, and we hope to see you soon on our next podcast. If anyone would like a replay of tonight, just let me know, and I'll make sure to forward it.
Thank you so much for organizing.
Thank you so much.
This, this was well needed.
There we go. That's and like I said, just text
and
me.
Thank you, Judge Hall.
No problem.
There we go, Judge.
You got 3 months.
Yeah.
Come on.
All right. All right, everyone. Have a great evening. Thank you all.
Okay, you guys do the same. Thank you.
Bye-bye.
Bye-bye.